We started our journey in contract from section 1, which is preliminary section. Then we moved to section 2, which talks of various terms, legislative dictionary basically, offer to contract, offer, acceptance, promise, consideration, agreement, enforceable, contract. We moved further. Section 3 said how communication will be made. Section 4 says when communication will be complete. Section 5 said up to what time revocation can be done. Section 6 says that revocation of offer will be done how. Section 7 talks about now absolute and unqualified acceptance. Section 8 says acceptance can be by conduct. Section 9 says that it can be express or implied. Section 10 says all agreements are contract if they are supported by free consent of the parties competent to contract for a lawful consideration or lawful object and not hereby expressly declared to be void. Is this all right? Now section 11 talks of that who is competent. Section 12 talks of insanity. Section 13 talks of consent. 14 talks of when consent is not free. 15 defines coercion. 16 talks of undue influence. 17 talks of fraud. 18 talks of misrepresentation. 19 when in these situations when consent is not free it will be voidable contract. 19 it talks about effect of undue influence. 20 says when both parties are mistaken about the subject matter, where the mistake is bilateral common mistake, then section 20 comes in picture. If it is bilateral mutual mistake, section 13 comes in picture. I have given example also that where a person wants to sell his black Mercedes and he has two Mercedes. He has two Mercedes black and white. He wants to sell his white Mercedes. He writes on black Mercedes. But you have seen him always on black Mercedes and you want to buy black Mercedes. He wants to sell his white Mercedes. You want to buy black. He wants to sell black. Is there any consent? The answer is no. This situation comes in section 13 where there is no consent at all. There is no consensus at item. No contract. No consent, no contract. But section 20 talks of common bilateral common mistake where we agree to sell black Mercedes and you agree to buy black Mercedes, but unfortunately neither of we are aware, neither of two are aware, black Mercedes is consumed by fire and then contract cannot be possible. This situation is called res extincta. Is this clear? So this is how section 20 is. Section 21 says that mistake which is about law, Indian law is no mistake, but mistake of foreign law is equivalent to mistake of fact. Section 22 says unilateral mistake is of no effect. You might have read a case, Haji Abdul Rakhia versus Bombay and Persia Steam Navigation Company case, where one person was under mistake. It is no mistake. Section 23 where consideration or object is unlawful. 6 situation I have said. 2, 3 just 6. You will have to memorize all this. This is very simple, prohibited by law. If it is permitted, it will defeat the provision of law. It involves or implies injury to personal property. It is fraudulent. Then court regards it as immoral or opposed to public policy. In 5th and 6th, it is court regards. That is what is the care and caution which we are required to adopt in answering questions. Section 24, blue pencil rule, I have already said. There are various rules in this Contract Act which may be asked in examination by the examiner, by the interviewer. Like section 7 is mirror rule. Section 4 talks of AB rule. I will upload a lecture on this also. AB rule, against A it is complete in B, against B it is complete in A. A in Ahmedabad, B in Bangalore. So if there is contract by postal method of communication, so against A The acceptance is complete in Bangalore and against B it is complete in Ahmedabad. So AB rule. I propounded that rule, AB rule. This is very useful information. Section 7 is mirror rule because acceptance must be as per offer. No qualification. It should be absolute and unqualified acceptance. Section 13, no consent, no contract. Section 20, I have just said res extincta. Section 19A was added in year 1899, undue influence, where the court has been given additional power to impose certain terms and conditions, which is not known otherwise. It's a unique provision. 21 deals with the effect of foreign law. 22 deals with the effect of unilateral mistake. 24, I said blue pencil rule, where the legal part and legal part can be severed, so legal part will remain valid, illegal part will be void. 25 is talks of nudum pactum, that is pact without consideration. 0, nude, bare. Agreement without consideration is void, that is nudum pactum. An agreement without consideration is void, but there are certain exceptions. Section 26, marriage, and if you marry, then there is need of doing some work, business, trade. Section 27, agreement in restraint of trade, and if you suffer loss, then there will be legal proceeding. So see, how can we be remembered? 26 is marriage, 27, if you marry, then you are required to earn money, so you will do trade. When you will do trade, there will be some kind of legal wrangle, so legal proceeding 28. And when you enter into legal proceeding, then there is uncertainty, section 29. And when you are uncertain to earn money, you will do wagering, section 30. And then the life becomes contingent. This way or that way. Kya karun ki kya na karun. Section 31 to 36. Now I must tell you, my dear friend, a very important observation. Section 36 has an example also, or even 34. 34, let me tell you, if I remember correctly, where there is an example of marriage. A says to B that I'll give you money if you marry C. C marries D. Now marriage of B with C is not possible. Once impossible, always impossible. Once impossible, always impossible. So now it cannot be said that D will die tomorrow and C will become unmarried again, and now marriage of B and C is possible. So now B can claim money from A. No, no, no. Must be very clear. Once impossible, always impossible. Law considers impossibility if it has happened once for all time to come. Law cannot be like this. It cannot be uncertain like this. तो ध्यान दीजिएगा मेरी बातों पर. Section 36. An agreement to do an impossible thing is void. Two lines cannot enclose a space. It is not possible. Now comes the question, after so much hurdle. I have already discussed with you other hurdles also. Animus contrahendi, intention to enter into contract. Animus contrahendi. Intention to enter into contract is necessary in formation of contract. Offer and acceptance create outward semblance of contract. But there is need of third contractual element, and that is intention to enter into legal relationship. That is there in Indian Contract Act also, which is not mentioned explicitly, but courts have accepted it. Because otherwise there will be no seriousness. How will you differentiate between family agreements and other business agreements? But that intention is the dividing line. No intention, no contract. And this intention must be objective, not subjective. You read Simpkins versus Page, where ladies have entered into some kind of arrangement and they fill up the crossword puzzle once they became successful, and now the senior lady says, I will not divide the price. Can it be said? So answer is no. Why? Because anybody looking to the facts and circumstances of the case will very clearly say that there was intention to enter into legal relationship. Test of intention is objective, not subjective. You have read all these things. Then possibility of performance, I said this is also an additional criteria. If agreement is not possible to be performed, it cannot be valid, like section 36, like section 20, like section 56. Everywhere there is impossibility. How can you sell a goods which is not there in existence? Section 20, res extincta. The goods are extinct. How can you perform a condition which is impossible? Section 36. An agreement contingent on impossible thing is void. And section 56, which says that the thing is itself impossible, like I say, I will sell you stars, I will sell you sun, I will bring moon for you. Can you do it? No. Section 56, para 1 says that this kind of agreement is void. So all these are very, very relevant questions. Be careful in reading, my dear friend. And do read carefully all these provisions, they are very, very important. Now comes the question of performance. It's very simple that when we enter into contract, it is to be performed. Obviously, if it is to be performed, who will perform the contract? Generally speaking, it is the parties to the contract who will perform the contract. You might be aware of privity of contract also. What is privity of contract? You have read about that. Many cases. Jamna Das versus Ram Avatar, a Privy Council decision of 1911 talks about this, and it says that privity of contract basically means that the parties to the contract can only ask for performance. They have the rights and duties in the contract, not third party. But there are various exceptions like beneficiary. If the contract has been for the benefit of third party, then they can. You might have read that case also, Betel Box expenses case, Hussaini Begum's case. Then you might have heard about trust. If I create a trust for benefit of somebody, they can claim the rights. I take an example from Consumer Protection Act. Suppose I am seller, you are buyer. You buy a product from me, but it is used by somebody else in your family, and they are injured. Can they file case against me or not? In Consumer Protection Act, even they can file a case against me. So Consumer Protection Act is also an exception. Then covenants running with land. If there is some condition running with land, then it will be binding on the person who buys that land, irrespective of the fact that when the condition was imposed, he was not a party to the contract. Just revise your earlier reading if you have read it. And if you have not read it, read it. It is important. It can be asked in examination. It can be asked in examination, my dear friend. So again, refer to AB rule. What is the place of conclusion of contract in postal method? So Bangalore in my example, and in instantaneous mode Ahmedabad in my example. Be careful. This can be a good question. What is mirror rule? Section 7 I said. What are the different conditions for valid contract? I said section 10 has 6 conditions, then there are 4 additional conditions which I was talking about. I said intention, possibility of performance, section 20, 36, 56 I was just talking about. Then legal formalities, section 25 has legal formalities, it should be written, it should be registered, another requirement, and then it should not be uncertain, section 29. Uncertainty is not favored by law. So 10 requirements. Must be careful. This is how you can create an impact in the mind of examiner. So AB rule, postal method, it is the place of acceptor. In instantaneous mode, it is the place of offerer, which is the place of conclusion of contract, and there the jurisdiction will lie. Mirror rule, section 7. Section 11, minority, and agreement by minor is void. You have read that case, Mori Bibi versus Dharmadas goes. Insane person, same situation, section 12. Section 13, doctrine of non est factum, it is not my deed. I have never done such an act, I am not aware of it. Doctrine of non est factum. Section 13, read it. It is not my deed, it is not the fact. I never signed such a document, I was befooled and I signed a document which was told to me that it is a sale deed, but it was a gift deed. Section 13 will come in picture. Can you forgive me for my mistake? Section 14, 15, 16, 17, 18. Can you forgive for my mistake? Can you forgive? You watch my lecture on YouTube also. Can you forgive me? Again you can see this. This is on the platform. I said res extincta. 24 I said blue pencil rule because you will run the pencil, so you will sever the illegal part. 25 nudum pactum. 28 there is an amendment I said. Just see, there is an amendment in 28. Now even age of majority is 18 years in all cases, you must know. Section 3 Indian Majority Act 1875 is amended. You should know all these things. 30 is wagering. Wagering agreement is void, it is not illegal. There is difference between void and illegal. In illegal you cannot claim anything which has been paid except in few situations, but in wagering you can. 31 to 36 I have already said contingent. Now the question of performance I was talking about. So generally in performance the party to contract. So I was talking of privity of contract. Now there is privity of consideration also. But I tell you, privity of consideration is applicable in English law. Privity of consideration is there in English law. In Indian law, there is no privity of consideration. We apply basically doctrine of constructive consideration. What is this doctrine of constructive consideration? Doctrine of constructive consideration means that promisee or any other person can give valid consideration. It is not necessary that party to contract can only give consideration. It can be even third party. Like now, you want to buy a car. Suppose I sell a car and you buy a car. But you do not have money. Your father, your mother, your relative can pay. So consideration is being given by third party. But who is the contracting party? You and me. You are buying. You are buying. But who is paying? Third party. This is what is called doctrine of constructive consideration. That even third party can pay consideration. Is this clear? So after reading this much you can see further performance of contract. Now in performance of contract I was saying that who will perform the contract? You can just think of. The contract will be performed by person who is party to the contract. There can be two kinds of contract. Contract may be of personal nature, may be of impersonal nature. Personal nature contract where your personal skill is involved, like writing a book, painting a picture, teaching, surgery, maybe that you may be interested in a particular person. But paying money, is it personal nature contract? If I have taken money from you, instead of me, my son can give you money back. My agent can give you money back. There is no involvement of personal skill in it. Just build this idea in your mind. Now, is it all right? Anybody can perform the contract if it is of impersonal nature. If it is of impersonal nature. Now then there is that there can be situation where there are many joint promisers and promisees. So where there is joint promisers and joint promisees, again anyone can do it. Anyone can do it. Promiser is bound to perform the promise. It is his duty to perform because he has promised. So any one of them can do it. And joint promises, any one of them can demand it. Now suppose in this case there is some kind of default by promiser in payment, etc. So can you claim it from them, any one of them or not? Yes. But if you claim it from one of them, can that person claim it from other promisers or not? The answer is yes. The answer is yes. This is as simple as that. So if there is any default in payment or if any default in work being done, then it will be said by the other promisers. This is what is the joint liability. This is what is the joint liability. I tell you the important principles of contract. Of course, in this situation, you can ask another question, that how to perform the contract. So see, contract can be performed by two ways. One by actual performance, another by offer of performance. Offer of performance is called a tender. I can actually perform or I can offer to perform if it is not fixed when to perform, where to perform, how to perform. So I will ask you, I will offer. Offer of performance is called tender of performance. If performance has to be done on a particular time is of the essence, and if you do not perform, obviously the other party will claim compensation or can reject the contract. Suppose it is my marriage today and you supply me the suit tomorrow, what will be the use of the suit? These are all commonsensical principles, so you can reject the contract. But if it is not of the essence, then you can only claim compensation. But even in that, you are required to keep in mind that when you accept the goods, you will have to tell me, no, see, I am accepting the goods, but I will claim compensation. Is this clear? See, in such kind of performances, the party who is required to perform, if he is not able to perform, he can tell you in advance also that I am not going to perform. This is what is called anticipatory breach. And if he does not perform on the actual date, anticipatory breach is written there in section 39. Section 39. And if he does not perform on the date when performance was due, then it is actual performance. Is this all right? Then there can be many situations where the agreement was valid in the beginning, but it becomes void later on due to intervention of government or due to change in circumstances. That is what is called frustration in section 56 para 2, which is called subsequent impossibility or frustration. Subsequent impossibility or frustration. So you are not required to perform. I tell you the pockets which are important here. Time is of the essence, section 55. Frustration, section 56. You can dispense with performance also. I am the party who can ask performance from you. I can say that you may not perform. Section 63. I can remit performance. You might have heard that in contract there is contract of debt, etc. also, where several debts are taken and several debts have to be paid. What is the rule? In this regard, there is CLAT's rule in section 59 of Indian Contract Act. CLAT's rule. CLAT's rule. Section 59. That if no prescription is there which date is to be paid, then it will be exercised by the discretion of the party who is paying it. Just have a glance. Contract Act is full with such kind of principles. Then there is a situation in 68 to 72 which is called Quasi contract, theory of unjust enrichment. These are those situations where there is no formation of basic contract, but because there is no offer and acceptance, but we apply principle of contract in the sense that it is almost like contract. This is basic principle in contract law. And then finally there is damages in 73 and penalty in 74. So there is nothing great. Penalty is not generally awarded, it is the reasonable compensation which will be awarded. So you just go through from section 71 to 75, you will have the feel of all of these things. Is this all right?